Yes.
Before the short adjournment, I was making submissions about the concept of personal data. I wanted to turn next to DPP7 itself and make our submissions about what it means and how it works. And DPP7 you'll find behind tab 2 in the authorities bundle at page 26. So, as you've seen, this is one of the data protection principles brought into play by section 4.4 of the Act, which my friend took you to, and I don't need to go back to it. Now, we say that there are at least 4 questions to which DPP7 gives rise, and one of the positive things about the Upper Tribunal's reasoning is that it carefully distinguishes between those 4 questions, those 4 stages of the analysis. The first question is, who does this obligation apply to? Answer, it applies to any person who is a data controller. We get that from section 4, subsection 4. DSG was a data controller, so DPP7 applies to it. The second question, in relation to what data does it apply? The answer to that is that it applies in relation to all of the personal data for which the relevant party here, DSG, is the data controller. And again, one gets that from section 4, subsection 4. The third question, and this needs to be carefully distinguished from the second question, the third question is, what is the content of the obligation in DPP7? That is to say, what are the eventualities which the data controller needs to protect against by taking appropriate technical and organizational measures? As to the content of the obligation, it's common ground between us that it breaks down into 2 separate obligations, but we differ as to the content of the 2 separate obligations and how each of them works. So what we've called in our skeleton obligation 1 is the obligation to take appropriate measures against unauthorized or unlawful processing of personal data. Then the second obligation is an obligation to take appropriate measures against accidental loss or destruction of or damage to personal data. In the monetary penalty notice and throughout these proceedings, the ICO has relied on the first obligation. It hasn't been suggested in relation to the EMV data or otherwise that DSG breached the second obligation. So the focus of the discussion, not surprisingly, in the Upper Tribunal's decision is primarily, though not solely, on obligation 1. Obligation 2 comes into the discussion in this hearing because there's a difference between us as to whether certain eventualities are covered by obligation 2 or the ICO says on their construction are covered by obligation 1. So obligation 1, what is it that the controller must take measures against? And the answer is the controller must take measures against the processing of personal data if such processing is unauthorized or unlawful. So the duty is to take measures against certain forms of processing of personal data, not merely against the processing of data. So perhaps to labour the point, does obligation 1 require the controller to take measures against a certain eventuality? answer yes if that eventuality involves the processing of personal data of the kind described here, namely unauthorized or unlawful, but not otherwise. We say what that means is that where the alleged breach consists of a failure to protect adequately against processing by a third-party intruder, there will be a breach of this first obligation if and only if the third party's processing would itself constitute the processing of personal data. And that would be the case if the data in question would be personal data in the hands of the third party, but not otherwise.
Sorry, can you say that again?
Yes, that would be the case if the data in question would be personal data in the hands of the third party. So let me perhaps unpack that a bit. The Information Commissioner comes along to a data controller and says, your security measures are inadequate because they create a risk of unauthorized access to this particular bucket of information that you hold. And the data controller can then say, well, we need to look a bit further than that. If that unauthorized access took place, would that access involve the processing of personal data? Well, if it's unauthorized access, if it's by a third party who has nothing to do with the data controller, that unauthorized access couldn't be processing of personal data by the data controller. The data controller wouldn't be doing anything in that scenario. So if it involves the processing of personal data, the only person who can be processing personal data in that eventuality is the attacker. If the data wouldn't be personal data in the attacker's hands, then no processing of personal data is taking place in that scenario, either by the controller or by the third party, from which it follows that this is not an eventuality that comes within the scope of obligation, of what I've been calling obligation 1. And that essentially is the analysis that the Upper Tribunal adopted. And it depends, as I've said, on making that careful distinction between the question of, in relation to what data does DPP7 apply, and the separate question, what is the content of the obligation? What are the things that you have to protect against? Now, contrast that with what we've called obligation 2, the obligation to take appropriate measures against accidental loss or destruction of or damage to personal data. Now, that doesn't depend on whether the third party intruder would be processing personal data, because it's not an obligation to take precautions against particular processing of personal data. It's an obligation to take precautions against a particular outcome, accidental loss, destruction, damage to personal data. So a third party may perfectly well render data inaccessible by the use of ransomware. And if the third party did that, we say that would involve the accidental either destruction of or damage to the personal data. And that is something that under obligation B, the data controller would be obliged to take measures against. Indeed, arguably, obligation 2 could apply in relation to third-party conduct that would not even involve the processing of data, let alone the processing of personal data.
Sorry to interrupt. Is one possible reading of this language that it is treating the words beginning with accidental, your obligation 2, as not encompassing any processing, so that obligation 1 is concerned with processing of the kinds described, and obligation 2 describing things concerned things that would not be processed.
That's a possible reading. I don't need to go that far. Obligation 2 encompasses things that wouldn't involve the processing of personal data by the person doing them. Now,
well, hold on. Destruction of data is processing.
It's not processing of personal data if the person destroying it doesn't know who the individuals are, but it would still constitute something that would come within obligation 2. So a third-party attacker comes into my system and detonates the equivalent of a cyber bomb that just destroys a large part of my system. And the attacker doesn't know what it is that's in there that they've destroyed, but they have in fact destroyed my access to a substantial part of personal data. Now, they haven't processed personal data. They have no idea who the individuals are. It's not processing of personal data by the attacker, but it still comes within obligation 2.
Sorry, the definition of processing in section 1 includes the destruction
Indeed.
of information or data.
Yes.
So by destroying it, they are processing it.
They're not.
You say they're not,
Yeah.
because they needed to be aware
Yeah.
that it was personal data.
They're not processing personal data because it's not personal data in their hands. They don't know the people who
It's
it
not in
relates
their
to.
hands. It's in the hands of, in this example, DSG. And
Yes,
it
but if
never
you-
goes out of
But if,
DSG's
but
hands.
if you ask the question whether the attacker is processing personal data, the attacker is not processing personal data because as far as the attacker is concerned, they have no idea who it relates to or even whether it's personal data or not.
So we go back to paragraph 7. We keep having to insert in some form or another from the perspective of the attacker, or whatever word you want to use.
But it can only be, you can only have the processing of personal data if it's personal data, and it can only be personal data from the perspective of somebody. So it's either got to be from the perspective of the controller or from the perspective of some other person, such as a third-party attacker. It can't be personal data in the abstract.
So there is no obligation on the controller of data to have measures to protect against the destruction of personal data when the attacker may or may not know that it is personal data. Is that it?
No, that's not what I'm saying. There is such an obligation, but that scenario, we say, comes under obligation 2, because what happens in that situation is that as a result of what the attacker does, personal data is damaged or destroyed. That is something that the controller has to protect against, but they protect against it under obligation 2, not under obligation 1.
I thought you were saying also under 2 that if the attacker doesn't know that it's personal data, then obligation 2 doesn't apply.
I'm not saying that, and if I gave that,
Then it's me.
My apologies if my apologies for being unclear.
No, it's me.
So if you have a situation where the attacker doesn't know who the data relates to, the attacker is not processing personal data, and therefore the obligation to safeguard against that eventuality doesn't come within obligation 1, but nevertheless what has happened is the destruction or damage to personal data, and that is a scenario that comes within obligation 2, and that is a scenario that the controller has to protect against. So the commissioner's concern, or one of them, is that on the Upper Tribunal's construction, there's no protection, there's no duty to protect against circumstances such as encryption by a third-party attacker. We say there is an obligation to protect against that, but that obligation comes within obligation 2, not obligation 1. The reason that distinction matters in this case is that the Commissioner has never suggested in relation to the EMV data that there was a breach of obligation 2. The Commissioner's case depends on obligation 1, So for our purposes, it's very important to identify the scope of obligation 1. So that's how we put it.
And this is because you say accidental only applies to loss.
We say accidental only applies to loss. We say accidental loss or destruction or damage, whether accidental or deliberate. We say there's no need to read the word accidental as applying to all the 3 elements, loss, destruction or damage. We say that's an interpretative choice that the Information Commission makes in their skeleton. And that's the choice that gives rise to the lacuna that they complain against. And if for no other reason, for that reason, one shouldn't read the language in that way.
So on this approach, you're reading in obligation 1, you're reading the phrase processing of personal data as
Yes.
a composite phrase.
Yes.
All of which has to be satisfied
Yes.
by the operation that is being undertaken.
Yes. The thing
Whereas
that's
in obligation 2,
Yeah.
you're reading personal data as a freestanding concept which is governed by the possession
Yes.
of identifying information.
yes,
as handled
because
in the
you
data.
don't have to trouble. I'm sorry, I was interrupting. You don't have to trouble yourself as to whether there's processing of personal data in obligation 2. Whereas in obligation 1, you have to say, well, is the processing of personal data in the eventuality that you're failing to protect against? If there is, who is it that's processing personal data? There must be some person.
On that approach, it is slightly problematic because, as my lord has pointed out, destruction is one of the things within the almost all-encompassing definition of processing.
Yes, so there could be. Yeah.
Leaving aside all the other things in obligation 2, we've got something that is processing,
Yes.
and we've got personal data, but on your analysis, it's not the same thing as what's going on in obligation 1.
There could be some overlap, I accept that, but what there isn't, we say, is a lacuna. Now, my friend's gloss on the relationship between obligation 1 and obligation 2, he said, obligation 1 is directed to things that are deliberate. Obligation 2 is directed to things that are accidental. He therefore says that if you have something like a third-party attacker who comes into a system and simply destroys part of it without even knowing what's in there, my friend says, well, that has to come within obligation 1 because it's a deliberate thing, not an accidental thing. We don't accept that construction. First of all, as to obligation 1, unauthorized or unlawful processing of personal data, there's nothing on the face of it to qualify it by the use of the word deliberate. And indeed, the processing of personal data may be either deliberate or accidental. So take, for example, the case, and it quite often happens, where a data controller accidentally discloses personal data to somebody to whom he didn't mean to disclose it. So you send out a sensitive email and you copy it to a whole load of people who have no business in seeing it. That involves processing of personal data. It's accidental, it's not deliberate. It would be the unlawful processing of personal data, because it would be processing that wouldn't be provided for by any of the data protection principles. Likewise, we don't suggest that obligation 1 only applies in relation to third-party attackers. So in the example I've just given, that would be unlawful processing by the controller, not by a third party. The DPP7 obligation could extend to requiring the controller to take measures against that kind of processing, e.g. by training their employees properly. On the facts of our case, the unauthorized or unlawful processing of personal data, which it said DSG failed to take measures against, was by third-party intruders. But it doesn't have to be that way. And likewise, as obligation 2, as I've said, we read the word accidental as qualifying loss, but not destruction or damage. I'll come back to that point a little later again, if I may, when I respond more directly to some of the submissions that were made this morning.
Sorry, I'm struggling with this. Processing includes, well, it's doing anything, but it includes blocking, erasure, or destruction. So
Yes.
it includes loss, destruction, or damage.
Yes. But
So if it's unauthorized or if it's unlawful, forget about deliberate, forget about anything else. If it's unauthorized or unlawful, blocking, erasure, or destruction, it's within the scope of unauthorized or unlawful processing. Stop there. Forget about our personal data. It's within that.
yes.
So how is it that one operates distinctly and separately from what you're describing as obligation 2, when they both can potentially cover the same thing? So you could say you're in breach of both parts of it on your analysis, because you could have a non-accidental destruction or damage, which is within unlawful processing.
May I go back to the definition of processing, which is at page 12 in
Yes.
the core bundle?
Yes.
Because there's some language in there that we haven't previously focused on, but which may assist on this. So at the foot of page 12, the definition, processing in relation to information or data means various things, including erasure or destruction.
Yes.
So within this scheme, you can process information, you can process data, you can process personal data. Now, if you have a case where somebody who has no idea what is in a system destroys part of it, and therefore destroys part of the information and data in that system, that person isn't processing personal data, because in their hands it's not personal data. They're processing information, they're processing data. As far as they're concerned, from their perspective, it's not a processing of personal data. But for the purposes of obligation 2, that doesn't matter, because what matters in obligation 1 is whether somebody is processing personal data. What matters in obligation 2 is whether personal data has been left in a state where it has been accidentally lost or destroyed or damaged. So that could come about as a result of something that doesn't in itself involve the processing of personal data, but nevertheless, the personal data is left in a state where it's been destroyed or damaged. So, what is significant is that the phrase processing of personal data appears in obligation 1 but not in obligation 2. If obligation 2 was framed by reference to the processing of personal data in such a way as to lead to its loss, destruction, or damage, then one would be in a different situation. So that's what we say about the content of DPP7. Can I then say something about the fourth aspect of it, which is the standard that one is expected to reach? And that is dealt with firstly by paragraph 9 at page 36 of the bundle. This tells you, or this helps to identify what is meant by an appropriate measure, what is the appropriate level of security. What it says is that the measures must ensure a level of security appropriate to A, the harm that might result.
Sorry, which page are you on?
Page 36
Thank you.
of the authorities bundle.
Yes.
So a level of security appropriate to A, the harm that might result from such unauthorized or unlawful processing or accidental loss, destruction or damage as are mentioned, and B, the nature of the data to be protected. Now, even if the Information Commissioner's construction is right, and so obligation 1 extends to a situation where processing would not involve the processing of personal data by a third-party attacker. You still need to know whether the personal data would be personal data in the hands of that attacker. You need to know, because that is something that will tell you what is the harm that might result and what is the nature of the data to be protected. So my friend accepts, and this was at the end of his submissions, he accepts that if the controller is able to say, well, look, even if this particular part of my system is attacked, all that will get out into the hands of a third party is vanilla data, not personal data. My friend accepts that if the controller can say that, then that will be relevant under paragraph 9 when you're deciding what is the appropriate level of security, which is why I said before the short adjournment that the difference between us is perhaps less than it might at first sight appear, because it's common ground that this question of whether the data would be personal data in the hands of a third party, it's common ground that that's relevant. My friend accepts it's relevant at the stage of paragraph 9. What he doesn't accept is that it's relevant at the anterior stage at paragraph 7.
Except you're defining the scope, the existence of the application of the paragraph 7, and you're saying that its existence depends on whether the unauthorized or unlawful processing of personal data is being undertaken by somebody in whose hands it would be personal data.
Yes.
It depends on whether it's, even though it's still on DSG's system,
Yes.
they're dealing with it on that system, so it's still in the hands of DSG.
Yes.
Nevertheless, for you, it's not personal data. And this is dealing with the extent of the duty or the scope
Yes.
of it. So I think there is quite a significant difference.
I said I said that there are 4 questions that DPP 7 gives rise to, and the third question I said is the scope of the duty, and the fourth is the standard that you have to reach. And my point here is that paragraph 9 is about the standard that you have to reach.
Yes.
Now, I accept that there's a difference, clearly, analytically. The reason I emphasise this point is that the submissions you heard this morning for the Commissioner, there was some emphasis there on how difficult it is for the controller to grapple with the question of whether data might be personal data in a third party's hands. And I say that concern by the Commissioner is overstated, and it's overstated because even on the Commissioner's own construction, that is something that has to be grappled with at the paragraph 9 stage, even if it doesn't come in at the paragraph 7 stage. Now, finally, the other principle that my friend took you to is at page 38, paragraph 11, where processing of personal data is carried out by a data processor on behalf of the data controller. The data controller must, in order to comply with the 7th principle, do certain things. My friend raised the question, well, what if the personal data is not personal data in the hands of the data processor? So the data processor isn't processing personal data, but it is personal data in the hands of the controller. That's a scenario that's very distant from anything on the facts of the present case. I would submit that in that situation, the data processor isn't themselves processing personal data, but the data controller is, which means that even if paragraph 11 itself doesn't apply, the data controller is still subject to the general obligations in DPP 7, because from the data controller's point of view, what's being processed is personal data. So in other words, it doesn't mean that the data controller is somehow off the hook simply by splitting their data and putting part of it in the hands of a processor in whose hands it's not personal data at all, because it's, from the processor's point of view, completely anonymized. So paragraph 11, we say, doesn't assist you. What I wanted to do, though, is to point up what we say is the very surprising consequence that follows from my friend's submissions. And in order to do that, can I perhaps go back to a case involving pseudonymization and give an example in relation to statistical information and how statistical information is held? So you will have seen from some of the earlier case law that in the freedom of information context, there's been discussion of cases where statistics are disclosed and whether statistical information is disclosive of individual identities, as it may be in cases where there are low numbers. So let me give this as an example. Let's assume that a local authority holds a set of forms giving information about which named individuals in particular districts are homeless. And it uses those forms to prepare statistical tables, and no names of individuals appear on those tables, they're just numbers. Now, in the hands of the local authority, the statistical tables may very well be personal data, since the authority can link the numbers on the tables with the information on the forms. If the statistics alone are disclosed or made public, they may very well not be personal data in the hands of the recipient, because the recipient doesn't have access to the forms. So, unless they're very small numbers, the likelihood is that a purely statistical disclosure will not be disclosure of personal data. You could therefore have a situation where my local authority, it holds forms, it holds statistics. The statistics are information that it could properly disclose under FOIA. It could properly and lawfully make that information public, not just to some third party, but to the world generally. Nevertheless, on the ICO's construction of DPP7, in the hands of the local authority, those statistical tables are personal data because it can link them to the forms. It therefore has to protect against unauthorized or unlawful processing of the personal data. So let's say it holds the tables insecurely and some third-party attacker gets hold of the tables. On my friend's submission, the Information Commissioner can come along and say, well, we now know that you were holding those tables insecurely and they were personal data in your hands, and therefore that was within the scope of DPP7. That was something that you had an obligation to protect against. You could have an obligation to protect against unauthorized access to information, even though that very same information you could lawfully disclose in response to the whole world, in response to an FOI request, or indeed voluntarily as part of. Would not the answer be the one that you've indicated, that the measures would be appropriate and sufficient because the consequences of the hypothetical breach are not significant? The answer might well be, in a particular case, yes, the answer probably would be, in paragraph 9, that the measures are appropriate, but I suggest that it's a bizarre situation that could even come within the scope of paragraph 7 and require you to go to paragraph 9, but that, I say, is the consequence of the construction for which the Information Commissioner is arguing, and really there's no there's no way of escaping that.
How do we decide whether the EMV data, as I think you're calling it, is or is not within the scope of paragraph 7? Hypothetically, there's been no breach. How do we decide whether or not there is an obligation on you as data controller to take appropriate, etc., measures to protect against its unauthorized?
The first thing we ask, we go through a series of steps.
Yes.
So the first step is to say, well, this EMV data, is it personal data in DSG's hands?
It is.
And the answer is yes.
Yes.
And what that means is that, firstly, that means it comes within the scope of DPP 7. And secondly, that means that obligation 2 applies in relation to it.
Well, and obligation 1?
No, because on our construction, in relation to obligation 1, you need to know what sort of unauthorized or unlawful processing you are talking about. So, as I've said, obligation 1 can extend to unauthorized or unlawful processing both by the controller and by third parties.
Yes.
Because it's personal data in our hands,
Yes.
we have to guard against unauthorized or unlawful processing of it ourselves.
Yes.
So we have to make sure that, for example, our employees don't accidentally delete it.
Yes.
As far as third-party attack is concerned, we need to know whether in the hands of a third-party attacker, it would constitute personal data.
I understand that. So how do you actually apply that? How do you say, well, what measures, I mean, how do you decide whether it may or may not be?
Well, then you have to ask yourself what the case law describes as the motivated intruder question. And a little later on, I was going to show the court some case law about that concept and how it operates.
Well, that's what they might do with it and how motivated they are. What I'm trying to identify is how somebody as the data controller decides whether or not, when they're looking at what measures they have to take, whether they have to protect against a third party unauthorizing processing in an unauthorized or unlawful manner.
Well, what you have to do is you have to make an assessment as to whether, from the third party's point of view, it would be personal data or not. That means you have to ask yourself the question, well, first of all, does this data on its face identify specific individuals? Answer in this case, no, the EMV data doesn't. Secondly, is the data out there that would enable a third party to identify these individuals? Now, who is the third party? One could, in theory, approach that by saying, well, the third party means the world in general, means the public. And that's how you approach the question in the FOIA context. Because the question that you ask under FOIA is, if we make this data public, are the people out there as part of the public who could identify individuals by reference to other information that would be available to them? In the case of attacks, in reality, you're likely to be thinking about malicious, i.e. criminal attackers. So if there was a criminal attack, a hack, would a hacker be able to re-identify these people on the basis of other information that might reasonably be available to them? And that is a question that in data protection, one comes up against the whole time. If this information is either made public or disclosed to a particular person or a particular class of people, will they be able to re-identify the individuals to whom it relates? So the first thing that you will need to do as a data controller is that if you have information that on its face doesn't identify anybody, and separately you hold the key that would allow re-identification, you need to make sure that that key is securely kept. Because if the key is not securely kept, then you're not protecting against the risk of processing of personal data, because if the key gets out and the pseudonymized data gets out, that will enable identification. Once you've protected the key, then what you've got to think about is what other information is there out there that would potentially enable re-identification. So just as you might go to a security expert in order to advise you about what are the current means of attack that hackers are using and what defensive measures do I need to take, you might also need advice about what are the sources available to third-party attackers that might enable them to re-identify people from information that is on its face not disclosive of individual identity.
And is this on what? The balance of probabilities, likelihood, risk, level of risk, nature of risk? What's the test you apply to decide whether or not you need to take these measures?
Well, the question is what is appropriate, and that is assessed in accordance with paragraph 9. And it's assessed by you're asking.
But that's assuming you're within the scope of paragraph 7. This debate is that you're not within the scope of paragraph 7 because you're dealing with hackers who might or might not have access to other information which would make your personal data in their hands.
Well, you're asking, when you ask, is it personal data in the hands of a third party, then you're doing the same exercise as you do in a FOIA case as to whether it would be personal data if made public, which is to say, you're looking at it from the point of view of a motivated intruder. A motivated intruder is somebody who has a particular interest in re-identifying the data. And you look at the steps that would be reasonably available to the motivated intruder in order to do that. Now, I'm making that submission in that rather kind of conclusory way. There's relevant authority which I can take the court to. I was going to come to that a little bit later, but yes, in summary, it's the same exercise that any public authority goes through when they're asking themselves the question, is this data that we can safely disclose under FOIA? Except that you're asking it not in relation to making the data public, but in relation to the data being accessed by, in realistic terms, accessed by a criminal intruder. So there is a structured way within the legislation of approaching that, within the legislation and within ICO guidance. And I mean, it may be helpful as we're on the point to turn up the relevant authority now. I think for present purposes, the most helpful case is behind tab 10. It's the Miller case. Now, this is a case about whether statistical information could be made public under the Freedom of Information Act, or whether making it public would be disclosive of personal data. The decision, both by the First-tier Tribunal and the Upper Tribunal, was that the information didn't constitute personal data because if it was made public in the hands of the public, it wouldn't be disclosive of individual identity. In other words, here are these statistics. The government department that's assembled them knows the individuals to which they relate, but if just the statistics are made public, that isn't disclosive of individual identity to everybody, to anybody rather. If I can perhaps invite the court to turn to page 298 in the bundle of authorities, and to perhaps read from paragraph 10 to paragraph 16. Rather than my reading that out, it might be quicker just to invite you to read that passage.
How far do you want us to read? 10
I was going to go to paragraph 16, up to and including paragraph 16. Yes.
Yes.
So, in the freedom of information context, that is telling you how, as a public authority subject to FOIA, you go about deciding whether a disclosure of information that is on its face, not disclosive of individuals' identities, would nevertheless be a disclosure of personal data, i.e., it would be personal data in the hands of the recipients, because they would be able to re-identify the individuals to which it relates. And that's the process that you would go to. And in order to apply DPP7 on our construction, it's a similar exercise where you say, well, in the hands of a third party, could individuals be re-identified even though this data is on its face not disclosive of personal identities? And that depends on the considerations set out in that passage from Miller by reference to recital 26 of the directive, and the need to consider the means reasonably likely to be available to enable an identification to take place. And I do make the comment that this process is very familiar in the context of freedom of information disclosures, where there needs to be consideration as to whether the data would be disclosive of individual identities when made public. And the Information Commissioner agrees that this is how FOI works. There was no suggestion from the Commissioner this morning that any of these FOIA cases are wrongly decided. The Commissioner just says, well, they don't assist in the present case. There's no suggestion, therefore, that there is any insuperable difficulty in applying this approach in the context of freedom of information. So, in the light of all of that, what I'd like to do is just to summarize what we say is the correct analysis, just pulling together these points. So, firstly, DSG is a data controller. Secondly, the EMV is personal data in DSG's hands. Thirdly, DSG therefore owes DPP7 obligations in relation to that data. Fourthly, the ICO's case is that DSG breached obligation 1 in relation to the EMV data by failing to protect it against third-party attackers. Now, in order to test that, you need to assume, for the purposes of this appeal, that it's not personal data in the hands of a third-party attacker. But if it's not personal data in the hands of a third-party attacker, then the conduct of a third-party attacker in relation to that data is not processing of personal data by anyone, either by DSG or by the third party. And because of that, DPP obligation 1 doesn't extend to this scenario. If there's no processing of personal data, then there can, of course, be no unauthorized or unlawful processing of personal data. So that is simply to pull together the points that I've been making. Now, what I would like to do now is just to go next to the Upper Tribunal decision. The Upper Tribunal effectively sets out the analysis that I've been putting forward is the analysis in the Upper Tribunal decision, perhaps in some respects better expressed. But if one looks at paragraph 107 of the Upper Tribunal decision, page 74 onwards of the core bundle. Now, I don't intend to go through the Upper Tribunal's reasoning, but what I did want to do is to draw your attention to one aspect of it, and that's in relation to obligation 2, as I've been calling it, and what the Upper Tribunal says at paragraph 117. The short point is that what the Upper Tribunal says at paragraph 117 is not wholly consistent with the analysis that I put forward, but what they say when refusing permission to appeal is consistent, and therefore the position that I'm putting forward is consistent with that aspect of what the Upper Tribunal has said. So can I look first of all at paragraph 117, page 77. So if I can pick it up about 6 lines down in paragraph 117, Upper Tribunal says DPP 7 imposes an obligation on the data controller to take appropriate steps to guard against 2 different kinds of risk. First risk, one that we've just discussed, the risk of third parties undertaking unauthorized or unlawful processing of personal data. And pausing there, obligation 1, I accept that that also extends to unauthorized or unlawful processing by the controller themselves, but that wasn't the scenario that the Upper Tribunal was concerned with. And then, the data controller is also required to take appropriate steps to guard against the distinct risk of accidental loss or destruction of or damage to personal data. In this scenario, the risk to be guarded against is the inadvertent actions of the data controller who accidentally loses, damages, or destroys personal data while it's in its possession. Now, on the construction that we're urging of obligation 2, it would extend to not just the inadvertent actions of the data controller, but also the deliberate actions of a malicious third party who damages or destroys personal data. And one sees the Upper Tribunal, in fact, accepting that when one looks at their reasons for refusing permission to appeal in page 90 of the core bundle behind tab 6. And this was in response to the ICO's lacuna argument. The ICO had argued that the Upper Tribunal's decision created a lacuna in terms of protecting personal data which had been pseudonymized from being deleted by a third-party malicious actor. Paragraph 8, the Upper Tribunal addresses that, and they talk about the scope of the second obligation in DPP 7. And if I can pick it up 5 lines from the bottom of page 91. So the second obligation will include, as we noted in paragraph 117, guarding against inadvertent actions of the data controller who accidentally loses or destroys such data. But the second obligation in DPP 7 is not limited to a requirement to protect against inadvertent loss or damage. It extends to a requirement to guard against destruction generally. As we noticed in para 1112, in order to decide whether DSG has breached DPP 7, it's necessary to determine whether it failed to take atoms to guard against a specific risk. And then I think I can move over and look at the final sentence in para 8. If the alleged risk was of destruction of personal data held or stored by DSG, consideration would need to be given to whether DSG had failed to take reasonable steps to guard against that risk. So while I accept that what the Upper Tribunal says at paragraph 117 is not wholly consistent with the submissions that I've made to you, what they say in that passage when refusing permission to appeal is consistent. Subject to that, the Upper Tribunal's analysis is entirely consistent with the analysis that I've been putting forward, and in terms of the error of law that's identified in the grounds of appeal, which is about their construction of obligation 1, we say they didn't err in that respect. Now, what I wanted to do now was to deal with the some of the case law, and then to deal with some of the points that my friend made this morning, and then finally to deal with what we say about the SRB case on which he relied and which is the subject of the supplementary skeletons. So in relation to the case law, can I first of all say something about the Morrison's case? It's behind tab 8. My friend made some points about that case, took you to it. I don't need to ask the court to turn it up, but just to make 1 or 2 points about Morrison's. So this case is about how the data protection provisions apply when personal data is used or accessed by a third party. It's about who is the controller in relation to which elements of processing. So in that case, Skelton, who was a Morrison's employee, he was given authorized access to payroll data for the purposes of his work. Because he had a grudge against his employer, he posted it online. The online posting of the data, that was processing of the personal data. And there was no question about identifiability. There was no doubt whatsoever that this was data that identified individuals. The employees brought proceedings against Morrison's arising out of that unlawful disclosure of their personal data. They said 3 things. They said first, Morrison's was directly liable for Skelton's processing. Secondly, that Morrison's was directly liable for breaching DPP 7 in respect to that processing. And thirdly, that Morrison's was vicariously liable for Skelton's processing. Now, as to that first point, direct liability, Skelton was the controller for his own unauthorized processing. It came within DPA 1998 because the data that he processed was personal data in his hands, and so he was processing personal data of which he was the controller. Morrison's was not the controller of Skelton's processing and was not directly responsible for it. So applying that here, the third-party attacker who accessed EMV data would be the controller for any processing of that data, but whether such processing fell within DPA 1998 would depend on whether it was personal data in the attacker's hands. If there's processing of personal data, the controller can only be the intruder, just as in the Morrison's case, the controller could only be Skelton. Now, I then wanted to say something about the FOI cases, and to a considerable extent, I've already said what I need to say about those cases. As you've heard, there's a FOIA exemption in cases where disclosure of personal data would breach the data protection principles. So if a public authority is asked for disclosure of information, then one of the possible exemptions is this is personal data and disclosure would breach the data protection principles. So that always requires a two-step analysis. Would the information disclosed be personal data? If it would the disclosure breach the data protection principles? And as you've seen from the cases that my friend took you to, in particular the Department of Health case, the abortion statistics case, even if you've got information that is personal data in the hands of the controller making the disclosure, it doesn't follow that it would be personal data in the hands of the public when it's disclosed to them. And if not, if it wouldn't, the disclosure isn't a disclosure of personal data, which means that you don't have to go through the exercise of asking whether the data protection principles apply, and the data protection exemption doesn't apply. So that situation requires the public authority to consider whether in the hands of the public this would be personal data. And I've shown you the Miller case by way of illustration of how one goes about doing that. So those cases are illustrative of the principle which is not in dispute, that the same information may be personal data in one person's hands but not another's. They are very much illustrative of how you go about deciding whether apparently innocuous data, if disclosed, would be personal data in the hands of a third party. And what they show is that the obligations of a controller in relation to personal data may depend not simply on whether it is personal data in the controller's hands, but on whether it is personal data in a third party's hands. The other point I make by reference to the FOI cases is a point that I've already made, namely that if the Information Commissioner's construction is right, you can have a situation where information could be made public under FOIA, but nevertheless, because in the hands of the controller, it is personal data, it therefore comes within the scope of the DPP7 obligation to protect against unauthorized access. And we say that that is a very surprising conclusion. Then as far as the European cases are concerned, there are two European cases. The Scania case about vehicle identification numbers. What one gets from that is the explanation as to how the same information can be personal data in the hands of one party but not another. As that is common ground, I don't need to take you back to the Scania case. The SRB case, I'll deal with that separately at the end of the submissions, following the structure of the skeleton arguments, where it was dealt with in supplementary skeletons. Now, turning then to some of the points that were made for the ICO this morning. I took 6 main arguments from the skeleton argument. My friend made his submissions under 4 headings. I'll try and make sure that one way or another I cover everything. So, firstly, my friend says that our construction of DPP7 requires personal data to bear different meanings at different points in the legislation. And he says that that is, firstly, not a sensible way to go about reading a statutory section, and secondly, inconsistent with generally accepted principles of statutory construction. We don't accept that our construction involves giving different meanings to the concept of personal data, or indeed of processing, or of any other of the key concepts. The meaning of personal data and the meaning of what constitutes processing of personal data, that is constant throughout DPP7 on our reading. Personal data, processing of personal data to the extent relevant, bear the same meaning. The point is that one has to consider the content of the obligations imposed in each case and the factual circumstances to which they apply. And when you are considering the possibility of a third-party attack, you need to ask yourself the question, well, what are the scenarios against which you may have to protect yourselves? Does that scenario involve a processing of personal data? If so, by whom? If the answer is by nobody, it falls outside obligation 1. You may still need to take protective measures under obligation 2. So you're not changing the meaning of personal data from one point to another. What you're doing is applying the stable, consistent meaning of personal data in relation to different possible factual scenarios. Then the lacuna that the ICO was concerned about. So the ICO is concerned about 2 consequences of our construction. One is the ICO says it leaves a gap in the protection, and the other is that the ICO says in a more general sense it gives rise to practical difficulties. As far as the alleged lacuna is concerned, the ICO is concerned about the situation in which a third party uses, for example, ransomware for the purpose of malicious destruction of data, or perhaps for the purpose of locking the data to make it inaccessible. The ICO says that this can occur whether or not the data affected would be personal data in the hands of the attacker. We agree. So we agree that the use of, for instance, ransomware doesn't in any sense depend on the third-party attacker being able to identify the people to whom personal data relates. Indeed, they may not even know whether the part of the system that they are attacking contains personal data at all or some other kind of data. But what we say is that DPP7 on our construction would protect against this obligation, this outcome rather, by way of obligation 2. That's what the Upper Tribunal said in the comments on the permission to appeal application, which I took you to earlier. So obligation 2 requires protection for personal data against accidental loss or damage or destruction. As far as the ransomware case is concerned, we say that that case involves either damage or destruction of personal data. So obligation 2 would cover that case. My friend suggested towards the end of his submissions that if you had a case where the malicious intruder locked down the data, encrypted the data, and wouldn't decrypt it, or wouldn't decrypt it unless a ransom was paid, my friend suggested that that wouldn't involve damage or destruction of personal data. We don't accept that. A situation where personal data is rendered inaccessible because of malicious encryption by a third party, we say that comfortably comes within an ordinary language meaning of damage. In any event, even if I'm wrong about that, it would involve the alteration of the data. And as I'll show you a little later on, that is one of the things that the directive requires there to be protection against. So if necessary, the word damage would need to be construed as extending to alteration, and the encryption case would involve alteration. The ICOs say that all the limbs of obligation 2 are confined to accidental events, so it wouldn't cover malicious events at all. We say that that is a construction that the ICO puts forward, and it's that construction that creates the lacuna that the ICO complains of. In other words, the problem, the so-called lacuna, is a problem of the ICO's making, not a problem of our making. If I can go back to our skeleton argument, please. So you have our skeleton argument at page 209 in the core bundle, and at paragraph 65, page 227, we set out what we say are the problems with the Commissioner's interpretation. This is the Commissioner's interpretation that the term accidental covers loss and destruction and damage, not just loss. So our first point, and this is page 228, there's simply no reason of principle or policy favouring that interpretation. The language is at worst ambiguous, at best favours our interpretation, so we say, why create a problem where none exists? Then the second point is one that my friend said that he didn't understand. He didn't understand the point because he was proceeding from his assumption that obligation 1 is about deliberate conduct and obligation 2 is about accidental conduct. As I've said, we don't accept that. Obligation 1 could extend to accidental things done by the controller, the accidental destruction of or damage to personal data by a controller. That would itself be the processing of personal data. That would come within obligation 1, and it would be unlawful if you accidentally destroy or damage personal data. You won't be able to satisfy a processing condition for that processing. So on the Commissioner's construction, we say that the obligation 2 conduct, which he says is only accidental conduct, is covered by obligation 1 anyway. On our construction, as I've explained, obligation 2 has an independent function, i.e. The sorts of processing that the Commissioner says would fall outside obligation 1 on our reading, we say, well, it comes within obligation 2. Then, thirdly, if we look at Article 17 of the directive, and I can take that from the skeleton without needing to turn it up. So the things that you have to protect personal data against: accidental or unlawful destruction or accidental loss, alteration, unauthorized disclosure or access. Now, there is protection. So the directive refers to accidental loss, accidental destruction or unlawful destruction, and it doesn't talk about damage, it talks about alteration. So it would be very odd to have a construction of DPP 7, which is the Commissioner's construction, where there is specific protection against accidental destruction, but not against unlawful destruction. It's more natural to take the word destruction as referring to or including deliberate destruction, as it would on our reading. And then to pick up a point that I've already made earlier, but to found it in the language of the directive doesn't refer to damage, but it does refer specifically to alteration, even if deliberate encryption doesn't involve damage, and we say it does, it would on any view involve alteration, and so the word damage would need to be construed as extending to it. And then finally, even if you do read the provision as referring to the word accidental in relation to each term, from the point of view of the controller, malicious destruction or damage would be accidental, i.e. not intended by the controller. So in relation to the alleged lacuna, we say there isn't a lacuna. We say on our construction, the sort of conduct that the Commissioner is particularly concerned about would be caught by obligation 2. Then, in relation to the case law, the Commissioner has said that the case law about freedom of information doesn't assist in the current case. I've already made my submissions as to what I say the court can take from the FOIA case law and how it assists the court. And then finally, the issue about practical difficulties. The ICO says that the Upper Tribunal's analysis makes life unduly difficult, both for the ICO and for controllers. And effectively, the ICO is making a point that was put to me earlier in argument by the court, which is this is a forward-looking duty. How is the controller supposed to know what form a third-party attack might take and what information might be available to the third-party attackers? Now, you've had my submissions about what the exercise is that the controller would have to go to, and the relationship between that exercise and the exercise that public authorities go through in relation to FOIA. You've also had my submission that even on the Commissioner's view, when it comes to looking at the standard of protection required, you would indeed need to consider what would be the consequences of any disclosure, including, necessarily, whether the disclosure would involve enabling people to be re-identified by third parties by the use of matching data, because that's in effect a paragraph 9 issue looking at the potential consequences of the disclosure and the damage that might be done. It's also important in my submission to approach the Information Commissioner's submissions on this with a degree of realism. And I make 3 points about that. One is the Commissioner was concerned that on the Upper Tribunal's approach, data controllers might become unduly complacent because they would think that all they had to do was pseudonymize data in their hands, and then that would effectively ensure compliance with DPP7. Now, that's not a fair representation of the consequences of our submissions, because for a start, in any pseudonymization case, the data controller would need to ensure that the key, the identifying key in its hands, was kept securely. And secondly, they would need to ensure that they were adequately protected against the sort of malicious encryption scenario that my friend was concerned with. We accept they would have to protect against that. We say that comes under obligation 2, not obligation 1. The other aspect where there's an element of realism required is that the exercise of looking forward and saying, well, if disclosed, would this be personal data in other people's hands, is a FOIA exercise, and the Commissioner hasn't suggested that in that context it causes impossible practical difficulties. So may I turn finally to what we say about the SRB case, and I can take that from our supplementary skeleton argument, which is at page 238 in the core bundle. So my friend's taken you through the facts in the SRB case. It's a situation in which information was disclosed by the SRB to Deloitte, and the question was, when you were looking at whether that disclosure was consistent with the privacy information that had been given by the controller, by SRB, under Article 15 of the relevant regulations. So did you need to ask whether the data would be personal data in the hands of SRB, or whether it would be personal data in the hands of Deloitte? And there are effectively two conclusions in that judgment. The first is that pseudonymization might very well mean that the information was personal data in the hands of the SRB, but not in the hands of Deloitte. Then the second conclusion was that because of the nature of the obligation at issue, the Article 15 obligation, it was important that the question of whether the information was personal data should be looked at from the point of view of the SRB, not from the point of view of Deloitte. And the reason for that is summarised at points 2 and 3 of our skeleton at page 240. What the court said was that the purpose of this obligation is to enable the data subject to make an informed decision whether to provide the personal data being collected. That data is part of the legal relationship between the data subject and the controller. It concerns information that needs to be provided to the data subject at the point of collection. And therefore, you have to look at this at the point of collection and from the point of view of the controller. Now, the Commissioner suggests that you read that across to the present circumstances. We say that Article 15, on the one hand, the privacy obligation, the privacy notice, and DPP 7 are different beasts. They're about different subject matter, they apply at different times, they're differently worded. Firstly, they're about transparency as opposed to data security. Secondly, they apply at different times. They apply, Article 15, the SRB obligation, applies at a specific point in time. It applies at the point that the controller receives personal data from the data subject. So necessarily you have to say, well, how can you construe this provision workably when it requires information to be given at a particular time, at a snapshot? That's not how DPP 7 works. DPP 7 applies throughout the period when personal data are being processed. Further, the CJAU refers to Article 15 as being part of the relationship between data subject and controller. Now, in one sense, that is a somewhat puzzling thing for the CJAU to say, because at one level, everything in the data protection legislation is there to protect data subjects. So from one point of view, everything in the legislation is about the relationship between data subject and data controller. What in my submission the CJAU had in mind here was that this is about a direct communication from the controller to the data subject that has to be made at a particular time, and therefore one's approach to the content of the obligation is conditioned by looking at what can realistically be expected of the controller at that particular time. Now, DPP7 is directed to the controller's obligations to personal data generally, whatever its source, over the entire period of time for which he holds it, and most significantly, it's directed at taking measures to prevent specific types of harm. So one then has to construe the language that defines the particular types of harm to which DPP7 is directed. So the short point is that while the SRB case is another illustration of the fact that the same information can be personal data in one person's hands and not in another's, the outcome in that case doesn't assist you in relation to the issue with which this appeal is concerned. May I just take a moment to see if those behind me...
Yes, of course.
No, so unless there's anything else I can assist with, those are my submissions.
Just one point in relation to the SRB case. If one was looking at the point of communication from the data controller to the data subject under Article 15 and asking, well, does the data controller need to forewarn the data subject of what it might do with data vis-à-vis third parties? Why wouldn't the conclusion be that, on your approach, that what was in contemplation would not be a disclosure of personal data, and therefore the Article 15 obligation doesn't bite?
Yes. What the CJEU has in mind in my submission is the fact that at this particular point in time, it's entirely contingent as to whether the controller will know what disclosure it might make to third parties, what third parties might be able to do with the data, whether it's going to be data in their hands, what the precise circumstances are, and therefore they can't be expected to make provision for questions about whether the data transferred would be data in the hands of the third party, because they don't know what their arrangements are going to be in relation to that transfer.
That point could be made against you, couldn't it, in relation to the prospective third-party attack?
Yes.
It's really the point that my lord was making.
Yes,
That
but
it's all speculative as to what is going to happen in the future, or what might happen.
yes, and my point there is that the obligation with which this court is concerned is a very different kind of obligation, and inevitably, on any view, will require an element of speculation. It will require an element of speculation as to what tools might be available to any third-party attacker. It will require an element of speculation as to whether data would be re-identifiable in the hands of an attacker, and whether I'm right or wrong. If I'm wrong, it requires that element of speculation under paragraph 9. If I'm right, it requires that element of speculation under paragraph 7. So, in a sense, one of the things that makes DPP7 different is that those elements of speculation run all the way through DPP7. It involves speculation about the behaviour of third parties who, necessarily are third parties that the data controller has no control over, no dealings with, knows nothing about. It's a completely different context as opposed to the Article 15 obligation, which is in relation to things that the controller will voluntarily do within the controller's ambit and remit. So the difference between Article 15 on the one hand and DPP7 on the other hand is in our submission so great that there's just not a helpful read across from the SRB decision to the current context.
Thank you very much.
Thank you. Yes. Yes, Mr. Milford.
Thank you, my lord. I've just got 4 points in reply, which should take me about 10 minutes.
Thank you.
The first is on the content of the DPP7 duty. Now, my learned friend says that effectively pseudonymizing it always necessarily, as a matter of law, removes it from the scope of the duty to protect against a third party's unlawful or unauthorized processing. And we say that's wrong for all the reasons that I gave him in opening. But it also dangerously weakens the protection of DPP7. And the reason that it does so is that on the one hand, whether or not pseudonymized data is re-identifiable once it gets out into the wider world may be a difficult question that will depend on all sorts of factors. But on the other hand, it is a legal question that has either a right or a wrong answer. It either is or is not personal data. There is no sliding scale. Now, DSG says that a data controller can rely on its analysis that information is not personal data to take the data out of the scope of the duty altogether, so that nothing further is required. But of course, if that analysis comes up with a wrong answer, there could be serious consequences because the pseudonymized data can still escape into the world and would be personal data after all. And that's why this question about the point in the analysis at which you have to decide whether something is personal data is a real world issue. Now, DSG also says that the data controller on the Information Commissioner's approach has to do the analysis anyway as to whether pseudonymized data is identifiable in the hands of the third party, because the harm that can result is relevant to the stringency of the measures that DPP7 demands you take, atoms, in other words. And that's paragraph 9 of part 2 of Schedule 1, tab 2 of your authorities, page 36. Now, a couple of points about that language. The first is that on my learned friend's analysis, it's not obvious that you do need to apply paragraph 9 of part 2 of the schedule as a matter of language, because the requirements of that paragraph only apply to the harm that might result from such unauthorized or unlawful processing, etc. And if, as he says, the exfiltration of pseudonymized personal data is not a type of unlawful processing, it's outside the scope of the duty altogether, then it's difficult to see how paragraph 9 applies. So in my submission, all of his eggs are in one basket, which is the analysis of whether this is personal data at all. But as I said, that may be a difficult question, and yet there's only one right answer. And there would be, in my submission, huge risks if the law said that a data controller can rely on its own answer to that question. Now, the Information Commissioner's approach is more nuanced. The Information Commissioner says pseudonymized data remains personal data to which the DPP7 duty to protect against unlawful or unauthorized processing applies, but you only need to apply a level of security that is appropriate to the likely harm. See paragraph 9. And that allows one to take a nuanced view of the likely risk of identification and of the seriousness of the consequences if it does occur, and apply security measures that are appropriate to all those things. And that may be nothing more than pseudonymization. So no doubt, if you had the hypothetical example in the Department of Health case about 100,000 people having abortions in any given year, it may be it's sufficient simply to pseudonymize that information, but it may be significantly more. But we do say that what Lord Hope said about this in Common Services Agency is absolutely clear, and in discussion with with the court. My Lord Justice Moylan raised it. It's paragraph 22, page 97 of the authorities. And it's the bit that says the primary focus of the definition, the duty in section 4.4 is all embracing, and the primary focus of the definition of the expression personal data is on him and on everything he does with that information. He cannot exclude personal data from the duty to comply with the data protection principles simply by editing the data so that if the edited part were to be disclosed to a third party, the third party would not find it possible from that part alone without the assistance of other information to identify a living individual. So, duty still applies. It may require little in a particular case, but it still applies. And finally, on this issue, my learned friend says, well, the Commissioner accepts that the analysis of whether data is personal data in the hands of the public needs to be done in FOIA circumstances. And he says, well, there's no suggestion that causes any particular difficulty. Now, first of all, the fact that one has a significant line of case law on this very issue rather suggests it may not be quite as unproblematic as DSG says. But secondly, where one is talking about FOIA and the release of pseudonymized data, as the cases show, one is generally talking about the controlled release of personal data in a form which either may no doubt have been created precisely in order to minimize risk, so the Barnardized statistics that you've got in Common Services Agency, or else is so obviously vanilla that there can't be any issue with its release. For example, the 100,000 statistic in the Department of Health case. But neither of those things will necessarily be the case with pseudonymized data on the data controller's own systems to which DPP7 applies. So that was the first point in reply. The second point in reply concerns obligation 1 and obligation 2 in DPP7. Now, my learned friend needs to be able to explain how obligation 2 applies to provide the protection that would otherwise be missing if obligation 1 doesn't apply to material that isn't personal data in the hands of the attacker. And he gets there by saying that obligation 2 applies to data that isn't personal data for the third party doing the processing, because he says the obligation concerns outcomes, destruction, damage, or loss, and not simply processing. But we say that makes no sense, and that's for the reason given in a discussion with the court and my Lord Justice Moylan. And it's because loss, destruction, and damage are themselves forms of processing. But more than that, they are forms of processing that are specifically addressed as processing in the language of the directive. And it's helpful to turn that up. See tab 1 of the authorities at page 10. If one looks there at Article 17, one can see that there's a sort of omnibus indication of the things that need to be protected against under security of processing, which ends with the final words, all other unlawful forms of processing. And that makes it clear that all the things that precede that phrase are to be treated, as is obviously common sense, as damaging forms of the processing of personal data. And those things include accidental loss, unlawful destruction, accidental destruction. So the very things that my learned friend says you just have to treat as outcomes for the purposes of his analysis. So we say that way of trying to distinguish obligation 1 and obligation 2 doesn't make any sense on its own terms or when one looks at the directive. So that's point 2. The third point that I wanted to make concerns my learned friend's statistical data example and what he says would be unreasonable regulatory action. So my learned friend gave an example of a local authority that could properly and lawfully make statistics public and said, well, on the Commissioner's construction, in the hands of the local authority, those statistical details would be personal data that could relate them to particular service users. And the suggestion is that the Commissioner could then come along and complain about breach of DPP7, even though in de-identified form it's completely vanilla data that could be released under FOIA. And the answer to that, in part, is that you only need to take appropriate technical and organisational measures, and if the data is vanilla data, then pseudonymisation may be enough. But there's also another protective filter in the Act against overburdensome regulatory action by the Commissioner, and that is the terms of Section 55A, which indicate when a monetary penalty notice can be issued, and one has that at tab 2, page 18. And if one looks at those terms of Section 55A, one will see that it applies to circumstances if the Commissioner is satisfied that A, there's been a serious contravention of Section 4.4 by the data controller, and B, the contravention was of a kind likely to cause substantial damage or substantial distress. And if, in my learned friend's example, one's talking about pure vanilla data, then the answer is it's plainly not going to meet that threshold. So that's the third of the 4 points I wanted to make. The last was just about reliance on the Upper Tribunal's PTA reasoning. And in my submission, it may be legitimate to rely on an Upper Tribunal's reasons on PTA in order to supplement reasoning in the judgment. But what is much more problematic, and what the case law cited by my learned friend does not establish, is to rely on an Upper Tribunal's reasons on PTA where those reasons contradict the reasons in its judgment. And it's the judgment itself, obviously, which contains the relevant reasons that need to be addressed on appeal. So that's all I wanted to say about that.
Thank you. Anything? Yeah. No. No. Thank you very much. Thank you all for your respective submissions. And I omitted to ask your respective juniors whether they wanted to follow, but I assume that they did not. We're going to reserve our judgments. They will be provided to you in due course for the usual very limited purposes. And we would expect once you've received them, we will be able to agree a draft order, but if not, we'll deal with anything outstanding on paper. So thank you all very much.
Court rise if able.